Hello, this is Radio Law on YouTube. This is Dr. John Olson. Welcome to this Radio Law audio blog. Today I'm going to continue talking about Judge Kavanaugh's nomination, specifically matters relating to his views on abortion. Now, there has been considerable controversy around Judge Kavanaugh's position on abortion. Some senators have raised the case of Garza v. Hagen, and the link to that case is below, where Judge Kavanaugh dissented from the majority. So in this blog, I'm going to try to clear up some of the myths in that case and to shed some light on what I consider to be a reasonable interpretation of Judge Kavanaugh's position on abortion. I shall be referring to the claimant in that case, Garza v. Hagen, as Jane Doe, which is common practice when referring to a minor. So here are the myths regarding this case as I see them. Myth 1. The claim that Jane Doe was raped in custody at a detention centre for unlawful immigrant minors. This is not true. Jane Doe was pregnant before she entered custody. She was not raped in custody, as has been claimed in the media. She was pregnant before she entered the United States. In her own country, she could not obtain an abortion. Myth 2. Some people are saying that Judge Kavanaugh's decision would have meant that Jane Doe would have had to extend her pregnancy beyond the time when it would have been safe to terminate. The implication is that Judge Kavanaugh endangered her health or her life. Worse, some have implied that he did so deliberately or recklessly. We need to bear in mind that when Judge Kavanaugh and the court decided this case, they had only one day to do so, and Jane Doe was by that time already 14 or 15 weeks pregnant. It should be pointed out that when she entered the United States, she was actually 8 weeks pregnant. Myth 3. Some people suspect that Judge Kavanaugh considers that immigrants do not have the same abortion rights as US citizens, but that is to ignore what he actually said. At paragraph 753 of the judgment in Garza v. Hagen, the link below, Judge Kavanaugh states that all the parties in the action recognized that Jane Doe has the same rights as any US citizen to an abortion under the law. What is not always recognized, though, is that the Supreme Court has held in a number of cases that the US government has a legitimate interest in protecting fetal life, and that there is no obligation on the government to facilitate abortion, although it may not impose an undue burden on Jane Doe, for example, by trying to prevent access to medical care. So what did Judge Kavanaugh actually say in his ruling, the ruling against which Jane Doe appealed? He said because Jane Doe was 17 years old, a minor child, a foreigner in the United States, and because she had no immediate family in the country, she ought to be transferred to the custody of an immigration sponsor. These are people who the government mandates to assist immigrant families, especially those in difficulties for reasons of health, pregnancy, and so on, as part of its official immigration sponsorship program. In other words, what Judge Kavanaugh was saying was that the child should not be alone when having to make such a momentous decision in her life, or when going through the abortion process. She needed counseling and support, which she could not get while in custody. People should note that the US government will not pay for an abortion or facilitate it. The US Supreme Court has said the government has no obligation to do so, but it does say that the government may not place an undue burden on Jane Doe in seeking an abortion. The opposition to Judge Kavanaugh on the DC Circuit Court was that it would take time to find an immigration sponsor. As can be easily imagined, there is a high demand for sponsors, and particularly in circumstances relating to a young pregnant girl. However, recall that the court was required to follow the law, and the law is that a person in custody can only have an abortion in these circumstances once she is out of custody. Judge Kavanaugh did not write this law. Now, the irony is that the majority of the court opposed Judge Kavanaugh in this decision, but the Supreme Court disagreed with the Circuit Court. So, in fact, contrary to the claims of some senators, Judge Kavanaugh did follow the precedent, and his view was in the mainstream. Not only did Judge Kavanaugh make the right decision according to the Supreme Court, but bear in mind that the court had to make its decision in an emergency situation. So the Garza v. Hagen case involving Jane Doe is indeed a tragic one. The problem with cases like this is that we live in an imperfect world. A young girl is sexually abused in her own country. Aged 17, she leaves home and heads for the US border. There she is picked up by the immigration authorities and put in detention. While in detention, she tries to obtain an abortion, and she is suddenly faced with the huge bureaucratic machinery of a modern Western government, and she has to deal with all of this in a foreign language. People have used this case of Garza v. Hagen as a rod to beat Judge Kavanaugh with, as though this reflects his constitutional position on abortion. For example, Senator Feinstein asked him whether he considered Roe v. Wade to have been correctly decided. Judge Kavanaugh stated that Roe v. Wade was settled law, although he did not believe all constitutional constitutional lawyers considered it to be so. However, he stated that it is precedent, but he would not answer whether he would uphold it or not when asked this question. How could he answer that he would uphold it? Roe v. Wade is a live issue in America, with passions high between both pro-life and pro-choice. If Judge Kavanaugh answered this question, he would be compromising his independence. Senator Feinstein knows this perfectly well, and she knew it when she asked him the question, and so she was really attempting to score a political point. One other matter relating to Senator Feinstein: she stated that this case showed that Judge Kavanaugh was ready to ignore precedent, but she forgot to say, or perhaps forgot altogether, that the Supreme Court upheld Judge Kavanaugh's view in Azar v. Garza, which was the government's appeal against the district court's decision. Now, another point-scoring attempt came from Senator Kamala Harris on this question. She tried to make out Judge Kavanaugh had praised Justice Rehnquist's dissent in Roe v. Wade, as though this meant that both Justice Rehnquist and Judge Kavanaugh opposed abortion constitutionally. Actually, Chief Justice Rehnquist dissented in that case on a technical point. He was concerned that the right to have an abortion was necessarily one of the unenumerated rights in the Constitution, specifically in the 9th and 14th Amendments. The Roe v. Wade court found that those protections were broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Before going on to discuss Chief Justice Rehnquist's position, you will be aware that the 9th Amendment to the Constitution in the Bill of Rights says, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." This dictum is known as the Unenumerated Rights Clause. What it is basically saying is that just because a right is not mentioned in the Bill of Rights does not mean it is not a right. So what Rehnquist was arguing against was that the right to an abortion was one of those rights referred to in the unenumerated rights mentioned in the 9th Amendment. Thus, it is not necessarily the case that he was saying that abortion should not be allowed. In fact, he does not say that at all. He is saying that the constitutional grounds for abortion advanced by the court are not valid. He was concerned that the Supreme Court might consider it right to open up the Bill of Rights to any number of unenumerated rights. In fact, the court could have found other ways to make abortion legal, could simply have struck down the Texas and related legislation from other states as void for vagueness. My understanding is that Judge Kavanaugh is concerned with this point too. We can add any number of rights on the basis that they conform to notions of privacy, respect for family life, and so on. I'm not taking a position on whether a person has a right to an abortion. I'm simply saying that we should be careful before ascribing that particular right to the unenumerated rights provision of the Constitution, and we should be even more careful about expanding rights indefinitely. So I hope in this audio blog I have been able to shed some light on the abortion controversy as it relates to Judge Kavanaugh's nomination for the Supreme Court. Thank you for listening. Goodbye.